Welcome back to The Explainer. Today, we're unpacking one of the absolutely most fascinating and honestly consequential legal battles in modern employment history. We're diving right into the landmark constitutional court case of Hoffmann versus South African Airways. You guys, this is the incredible true story of just one man who took on an entire national airline. And he was fighting not just for his absolute dream job, but for fundamental human dignity, and for objective medical science to actually triumph over corporate stereotyping. So, can an invisible virus really disqualify you from your dream job? Well, imagine doing literally everything right. You crush the interviews, you prove you're more than competent, you beat out hundreds of competitors, and the finish line is right there in front of you. But then, a single drop of blood changes the whole shebang. That is exactly the core conflict Mr. Jacques Charl Hoffmann was facing. Let's look at exactly how this all played out. Part 1. The Dream and the Denial. Jacques Charl Hoffmann's Pursuit of the Skies. Okay, let's set the scene. The year is 1996, and Mr. Hoffmann has a crystal clear ambition. He wants to be a cabin attendant for South African Airways. And in September of that year, he didn't just apply, he totally excelled. Step 1, he successfully navigates this incredibly grueling 4-stage interview process. We're talking pre-screening, psychometric testing, formal interviews, and a final role play. He absolutely nailed it. Then, step 2, he goes through a clinical medical exam and is officially deemed completely fit for employment. But then we hit step 3. SAA required a pre-employment blood test for HIV, and when Hoffmann's results came back positive, his medical report was literally altered by SAA to read unsuitable. Just like that, the stroke of a pen completely derailed his career. To put this into perspective, Hoffmann was selected as one of only 12 suitable candidates out of a massive pool of 173 applicants. He was at the absolute top of the pack. Yet, he was rejected. And it's really crucial for us to understand here that both sides eventually agreed on this fact. He was turned away solely because of his HIV-positive status. That was the one and only reason. The sheer heartbreak, and frankly, the stark unfairness of this moment, became the catalyst for a monumental legal showdown. Moving on to Part 2, SAA's defense and justifications, fear, flights, and the High Court. Now, SAA didn't just roll over and admit to unfair prejudice. No, they built this massive, multi-layered defense to the High Court. And get this, initially, the High Court actually bought it. SAA claimed that flight crews have to be fit for worldwide duty, right? Meaning flying to countries where yellow fever is endemic. They argued that HIV-positive individuals might react negatively to the mandatory yellow fever vaccine. On top of that, they claimed HIV-positive people were highly prone to opportunistic diseases, like tuberculosis, which they said could compromise passenger safety in a mid-air emergency. And finally, they threw in this commercial argument. They claimed the life expectancy of someone with HIV was simply too short to warrant the airline's training costs. So SAA was basically painting a picture of immense medical and operational risk. Part 3. The medical reality of HIV, separating fact from prejudice. So we have to ask, was SAA's picture actually accurate? Well, to find out, we really need to look at the 4 stages of untreated HIV, exactly as presented by the medical experts. And that actually includes SAA's very own expert, Professor Schub. Okay, so stage 1 is the acute stage, where you see temporary flu-like symptoms. But then we get to stage 2, which is asymptomatic immunocompetent. During this stage, the individual functions completely normally. The infection is clinically silent. Now, it's only when looking at stages 3 and 4 that the immune system starts becoming suppressed or profoundly depleted. And the medical evidence here showed undeniably that Mr. Hoffmann was in stage 2. He was perfectly healthy, functioning totally normally, and entirely asymptomatic. But SAA was treating him as if he was already in stage 4. To really grasp an HIV-positive patient's true fitness for duty, you have to know that doctors don't just look at a simple positive or negative test result. What they actually look at is the CD4+ count. So what's that? It's basically an immune cell count in the blood, and it's used as a marker to really accurately predict someone's immune function. And the experts universally agreed that only when this specific count drops below a certain threshold, specifically below 350 cells per microliter, does a person become unable to take a yellow fever vaccine or become vulnerable to those secondary infections. And this brilliantly illustrates the massive gap between the airline's myth and actual scientific fact. On one hand, you had SAA making this huge blanket assumption that literally all people with HIV are prone to diseases and absolutely cannot be vaccinated. But on the other hand, the actual medical consensus proved that asymptomatic HIV-positive people who have sufficient CD4 plus counts can be completely safely vaccinated. They pose absolutely inconsequential hazards to passengers, and they can perform all cabin crew tasks competently. So it turns out SAA's policy wasn't based on an individual's actual health at all. It was based entirely on an unfounded stereotype. In fact, it was so clear-cut that the medical experts for both sides actually came together and issued a unanimous, really striking minute. They stated, there is no well-founded medical support for a policy that all persons who are HIV-positive are unable to be vaccinated for yellow fever. Boom. That quote completely invalidated SAA's medical defense. And because of that, SAA was literally forced to concede that their policy just couldn't be justified on medical grounds. Which brings us to part 4. Equality under the Constitution. The fight for human dignity. Right, so with the medical defense totally dismantled, the battleground shifted over to the highest law in the land. The core legal issue here rested squarely on Section 9 of the South African Constitution, the Equality Clause. The court noted that SAA, acting as an organ of the state, may not unfairly discriminate, directly or indirectly. The absolute determining factor? It's the impact on the person's human dignity. The court clearly recognized that people living with HIV are a highly vulnerable, deeply stigmatized minority facing severe systemic disadvantage. And crucially, the court made it incredibly clear that you cannot justify discrimination based on ill-informed public hysteria, or what they called commercial stereotyping. Basically, just because a company thinks a policy looks better to the public, that does not give them the right to trample on human dignity. Oh, and the court also pointed out a totally glaring hypocrisy in SAA's policies. Think about this. On one hand, their hiring policy automatically disqualified any new applicant who was HIV positive. But at the exact same time, they allowed their existing cabin crew to just keep flying worldwide routes without ever testing them for HIV. You have to ask, if SAA was truly that terrified of the safety risks of HIV-positive crew members, why on earth weren't they testing the people already flying their planes? That blatant inconsistency proved the policy was completely arbitrary. To bring this all home, the court drew upon a really profound foundational value, Ubuntu. Ubuntu is essentially the recognition of human worth and having deep respect for the dignity of every single person. It's a foundational value that truly calls for compassion. The court used this concept to argue that society absolutely must show Ubuntu towards people living with HIV. They stated forcefully that people must not be condemned to economic death by being denied an equal opportunity in employment. And now for the climax, Part 5, the verdict and the remedy, Justice Ngobo's landmark ruling. So, with the objective science and the constitutional imperatives crystal clear, what was the final verdict? Well, delivering the judgment, Justice Ngobo handed down a truly emotionally punching ruling. He said fear and ignorance can never justify the denial to all people who are HIV positive of the fundamental right to be judged on their merits. It's such a powerful statement. The Constitutional Court unequivocally ruled that SAA had violated Jacques Charl Hoffmann's right to equality and that they had impaired his dignity. It was a complete, top-to-bottom rejection of corporate stereotyping. But, just finding SAA guilty wasn't quite enough. The court actually had to provide a remedy. And they didn't just slap SAA on the wrist and award Mr. Hoffmann some financial damages. No, the remedy was instatement. The court declared that the absolute fullest redress obtainable is putting the person in the exact position they would have been in if the discrimination had never happened in the first place. So SAA was ordered to immediately offer Jacques Charl Hoffmann the exact cabin attendant position he had rightfully earned years prior. 30. That is the exact number of days the Constitutional Court gave SAA to make that formal job offer to Mr. Hoffmann. And on top of that, SAA was ordered to fully cover the extensive legal costs he incurred while fighting for his rights across multiple courts. It wasn't just a win, it was a total sweeping victory. So I want to leave you with a final thought to chew on. How does this landmark victory continue to protect marginalized groups from workplace prejudice and bad science even today? You see, the Hoffmann case wasn't just about one man and one airline. It set a massive enduring precedent. It established once and for all that corporate policies absolutely must be grounded in objective facts, not fear, and that human dignity must always be the North Star of employment law. Thank you so much for joining me on this deep dive into the explainer. I hope this gave you a clear, structured understanding of a truly historic moment in constitutional law. Keep questioning, keep learning, and I will catch you guys next time.